Hello, everyone. I think it's just about time to get started. Welcome, future U.S. lawyers. I had to add U.S. because I know that many of you attending today may already be lawyers in other countries, and you're here to learn more of the specifics of the U.S. court system with perhaps a U.S. bar exam in your future or near future. We're also welcoming all bar students who want an overall kind of big picture. It sometimes helps fit things together. And even our law students who are in that same place. This should help all of you. It is a more of an overview type of webinar today, and to help get a broad, big picture of what we'll be talking about. Jennifer and I, oh, hi, Jen. I know you're here. Jen's, oh, yeah, Jen's going to chime in. Oh, you have the official background. I forgot to do that. This is my office. I'll go ahead and do that. I'll BarMax this up because, of course, we are BarMax. Okay. And what I'm going to be covering today is the difference between the state and the federal courts, how they relate to each other. Jen is going to be talking of some of the unique features of our adversarial process. I saw her presentation. Parts of it are fun, but parts of it are also a nod to some challenging material that we cover in more detail in the BarMax course, but hopefully this will help you understand the context of what you're studying when you get there. And then if we have time, I will touch on some federalism issues. Again, this is a big ball of wax and a very complicated area of law. The part that's tested on the bar is fairly specific. There are certain rules and issues that are tested over and over again. I won't cover them all, but I'll give you the big picture. So I've said that a lot. This is more general today. Now, of course, if you don't have BarMax, we encourage you to get it. And we offer BarMax packages, and we offer, these are our comprehensive programs, but we also offer tutoring, and we also offer bundles where we combine tutoring and the course together, and you save money. One more announcement over here. I have put Q&A for instructors in Q&A. So you'll notice that in this webinar, we have chat and we have Q&A. You can say hello to each other, or you can ask questions of Katie from BarMax. She's here to answer any questions you have about BarMax, or if you are raising some specific issues with your own bar exam prep and need someone from BarMax to contact you, then go ahead and communicate with Katie. She's in chat. You can say hello to everyone by hitting all panelists and participants, but and try not to abuse that because it pops up a lot and drives people crazy. But if you have questions that are specific to the material, maybe something that Jenna and I say isn't as clear as it could be, or other questions about the topics we're covering today, throw them in Q&A, and we will be sure to save time for Q&A as well. So that's all my housekeeping. I'm going to get started with state courts versus federal courts, and then I'm going to pass the baton to Jen to cover the adversarial process. So the first thing to know is that when we talk about the U.S. courts, we're not just talking about one court system. Really, we're talking about more than 51 different systems, because we also have the District of Columbia and territories. But let's just say we have states, and each of these states has their own system of state courts. And then we also have the system of federal courts. So that's what I'm going to talk about for a minute here to clarify that. In state court, there are various levels of court, and I have simplified it as simple as it can be here typically you have some sort of trial courts. Now, they might be called circuit courts. In a lot of states, they're called circuit courts. They might be called superior courts, which seems silly because they're the lowest level, but there you go. And New York calls that low level of court the Supreme Court. Go figure that out. I don't understand either. California has a structure that looks a lot like that. Superior Court, Courts of Appeal, Supreme Court. So that's the lowest trial level, the ones in green here, okay, whether it's called superior or circuit or anything else. Then if appeals are taken from those decisions, they go to an appellate level of court. In California, you can see here, it's called the Courts of Appeal. I'll give some more examples in a moment. And then they go to the highest court for that state, which is generally, not everywhere, but generally called the Supreme Court of that state. So we have the Supreme Court of California, for example. Or in this example, we have the Supreme Court of Oregon. Okay, and I've given one of the more complicated charts here so you can see that there isn't just one circuit court. There are actually other kinds of lower courts. Some of them do see appeals in the circuit court, and then, so they have an extra level of appellate process. What are those lower levels of court? Typically things like probate court, which only handles estates, wills, things like that. Juvenile court might be in those lower levels of courts. There might be specialized courts for municipal courts, for fines levied by your city for, various, parking infractions or traffic or whatever. So there can be different levels, as you see here in Oregon, as you see here in Georgia. Okay, there are different levels of court. Now, do you need to know this for the bar exam? No. What you need to know is that we have state courts and federal courts. And I'll show you why. I'll show you some questions where you need to be able to distinguish the two. If we want to go nuts, we can look at New York. And again, you do not need to know this for the bar exam. Like I said, New York calls their lowest court the Supreme Court, go figure. And then they call the next one the appellate division of the Supreme Court, and then the Court of Appeals is at the top. You did not know that New York was that special. But they're not totally special because look, New York is here, it's highlighted in red. That means it is a UBE state. What's important about that? Uniform bar exam. If you are taking the bar exam in any of these states, save Michigan. Okay, Michigan starts in 2023. Right now, Michigan has its own weird thing, but in 2023, it joins the UBE family. So all of these states highlighted here in red are UBE, Uniform Bar Exam states, and they take the same bar exam. You do not need to know state-specific law. They've agreed among themselves that students can answer the questions, including the essays, according to generally applicable principles of law. Okay, so they might vary state to state, and if they do, a smarty pants essay might be able to say in some states, this would be the rule with this analysis and this result. In other states, this would be the rule with this analysis and this result. And you don't actually have to know which one is your specific state. You'll get all the credit for doing that. So important to know that you don't need to know the names of the courts in your state. You don't need to know what gets appealed where. Now, some states give an additional test, typically a lot easier than the bar exam, typically online. New York provides you first materials, you study the little course they give you, you take the test. Much easier than the bar exam. You do it all online. So that is completely separate, and you will need to know state-specific stuff for that, but not for the bar exam. So now we know we have state systems, 50 of them, and different things going on, different other US jurisdictions. And then we have the federal system. So this means if I were going to go, if I lived in Woodford County, Illinois, why did I pick this? My husband's from here. So my father-in-law still lives here. So there you go. There is the county courthouse of Woodford County, Illinois. Okay. It's sort of north central Illinois. And a lot of counties throughout the country, especially in the middle of the country, have these gorgeous old historic county courthouses. So there you go. If I were living in Woodford County and wanted to file a lawsuit, or if I want to go file a lawsuit more specifically against, I don't know, my father-in-law, don't worry, I'm not going to sue my father-in-law. We get along great. But if I were going to sue my father-in-law, right? If I want to file that lawsuit in state court, I would go here. If I want to file that lawsuit in federal court, well, then I would go to the federal court, which in this case would be the Northern District of Illinois, the Dirksen Federal Building in downtown Chicago. You only see a portion of it there. It is a towering hunk of glass and steel. And you'll learn in the civil procedure classes which cases are allowed in federal court. But almost everything is allowed in state court. So I might have a claim against my father-in-law. Oh, poor Lee, I'm so sorry. I swear we get along. But I have a claim against my father-in-law, and I may be able to file it in either state or federal court. I might decide for strategic reasons to do one or the other. And here's my county. I live in Indiana. The building is not as historic, right? This courthouse is the federal courthouse. It's actually closer to my house, but my county courthouse is, not so far away, and it would be here. Okay, if I were filing in state court versus federal court. Now, state courts are competent to hear federal cases. So if I am suing under a federal statute, state courts are competent to hear most of those. The Constitution delineates a narrow set of cases that can't be heard in state court. That would be copyright, bankruptcy, admiralty. Okay, we're not doing anything at sea. I'm not suing him about something that happened on a ship. So it's not admiralty. So there are some specialized areas that only federal courts can hear. And there are some specialized areas like probate, custody issues and family law, stuff like that, that only state courts can hear. But there are many, many issues that could go to either court. Okay, so I hope that helps you know that a lawsuit could start in either place. So we saw that there are just as there are 3 levels in most states, we have 3 levels in the US court system, the federal court system. So where I would sue my father-in-law in a federal case, if the incident occurred in my town here, and I'm in a different state than he is. So if it occurred in my town, I could go to the federal courthouse, sue him in federal court. This would be the U.S. District Court for the Northern District of Indiana. How about that? That's where I live, the Northern District of Indiana. And these are just examples. I'll show you a map of all the districts. That is the basic level of trial court. Now, the courts of appeal are called, United States Courts of Appeal, and they're also called circuit courts because the official name, if I went here, because guess what? The top few floors are reserved for the circuit court. So there's a lot of district court judges throughout this building. I had the pleasure of working there for a while. It's actually kind of a wonderful place. I really enjoyed working at Dirksen. But if you go higher up, literally and figuratively, the appeal would be filed with the United States Court of Appeal for the Seventh Circuit. Why the Seventh Circuit? Well, the whole country is split up into these 12 different circuits. There's the 11 that you see here, plus a federal circuit. Actually, no, I'm sorry, 13. There's a federal circuit and a DC circuit. Again, you don't need to know the names of the circuits or the states they cover or anything like that for the bar exam, but it's helpful to know that that's where appeals from the district court go. They go to your local circuit. So here I am in Indiana, in case you needed a refresher on where Indiana is. It's okay if you live somewhere else. Or if you're not in the US, there's a state called Indiana. That's and then here's Illinois, because I don't expect you to know everything about my country. I'm just not going to do that. I don't know everything. So here's Indiana, here's Illinois. If I brought the case here or here, either way, it's this part. It's the Seventh Circuit Court of Appeals would hear the appeal from that case. Ninth Circuit encompasses California and several other Western states, and so forth. Okay, so if the case gets appealed further, it goes to the United States Supreme Court. And as you'll learn in the constitutional law course, the United States Supreme Court gets to pick and choose which cases it takes. And you may know that already from the news. They grant certiorari, or I don't know, cert. People pronounce it different ways. But they allow the case to be heard in the Supreme Court. So the final appeal would be the US Supreme Court. And I will talk about, in a federal case, the final appeal in a federal case will be the US Supreme Court. When I get to federalism, I'll talk about why that might not always be the case in a state law case. In fact, it usually isn't. And we'll get to that, but we covered this. But what do you need to know for the bar exam? Look, we want you to notice when you're reading a question, and this is just a sample civil procedure question, we want you to notice what court the lawsuit is filed in, because that's going to determine some of the rules that apply. Here, we're in federal court in state B. Notice they don't say Indiana, Illinois, Oregon, Wisconsin, or any other state. They don't use a state name. They just say state A, state B. Okay. So we don't have to know the specifics, but we have to know how the system works, if that makes sense. So in federal court in state B, that's where this case is brought. That's going to govern, like, do we have jurisdiction over these people? You know, what's the rule for service of process? There's going to be a lot of things that are governed by where we are. Here's another civil procedure question where I want you to notice that there are two lawsuits going on, and we need to pay attention to where they are, because the first one took place in state court and the second one took place in federal court. Now, actually, for this particular question, it would have come to the same conclusion if it were a federal court somewhere else in the country, federal court in, one district versus another district, because this question is testing a concept called preclusion. It's at the very end of the civil procedure course, and it means that if you have already sued somebody about something and lost, you don't get to bring that lawsuit again. Okay, you can't bring the same claim again. You can't take a second bite at the apple, they always say. It's kind of a bad analogy because there's lots of bites in a real apple, but you only get one bite at the apple when it comes to filing a lawsuit. All right, so there we go. We've got our U.S. courts, district courts, circuit courts of appeal, and the Supreme Court. We've got our state courts at the trial, appellate, and Supreme Court levels. And we want to be noticing where we are. It comes up in constitutional law too, because some of the issues about who can be in court, what cases can be brought, comes straight from the U.S. Constitution, and this is one of them. Here we're in federal district court. And this ends up being a question about who is allowed to bring a claim in federal court. That's an issue called standing, and it's taught in BarMax in the first part of the constitutional law course. Okay, so that's all I wanted to cover. I warned you it would be, big picture view, and somewhat basic, but I want to make sure that we're clear on those points so that as you dive into the doctrines and the weeds, you have you kind of know where you are. You know where you are. So I've done that with state courts and federal courts, and I am going to ask Jennifer to cover. I'll stop sharing my screen, and I'm going to give Jennifer an opportunity to share her screen because she also has a presentation. And she's going to share about our next point, the adversarial process.
Okay, so welcome. So I'm very excited to learn all about the different courthouses in other parts of the country. That's amazing. And by the way, like to me that, in the United States, we sometimes talk about some of those states in the middle, we call them the flyover states. And so I don't necessarily think about them as flyover states, but I do think about them as those states that start with O's and I's and things like that. And I'm like, they're like kind of right there in the middle. And like, there's like Illinois and Indiana and I don't know, like Ohio. And so now I'm much more familiar with the geography and all of that. So
there you go. No extra charge. All right. Thanks so much, Jen. I'm going to let you take over.
There you go. So, when Celeste and I were kind of talking about, what do we want to talk about? Like, what should we think? What do we want to present about? One of the things that we were realizing is, for folks who are either coming back to the law, they've been away from it for a while, or folks who are foreign educated, so they're lawyers in another country, and they're really being introduced to the United States legal system for the first time. So they're familiar with the law and they're familiar with, how a legal process works. What are we seeing them struggle with? And we've become familiar with that because we've worked with these students one-on-one in tutoring sessions. And we've, had the opportunity to sit down with them and say, okay, what kind of questions do you have? And so, that was where this session came from. And so, what were the questions that students were asking us? And that was true of students who were, even coming from, let's say, the UK or other similar systems where they, even just like, hey, solicitors versus barristers. And it's like, no, we don't make that distinction here. That kind of thing. And we really realized just a super basic, hey, this is just an introduction. And so, we hope that this will sort of allow you to be situated and have kind of an overview of, okay, this is everything that we're kind of an introduction, a little acquaintanceship of what you're going to get to know in much deeper level later on throughout your bar prep course. So that's really what today is meant to be. And I would say if, at the end of this, you think to yourselves, gosh, I wish that I knew more about X. Don't hesitate to reach out and don't forget that we are available for individual sessions as well. We're also happy to hear like, hey, this is something I think you guys should do another session on, group session like this as well. We're happy to do that. Okay, so now I'm going to do the share screen. And okay, so now, all right. So the first thing that I do want to talk about, I'm going to talk about a couple of things, but so I want to introduce the process and kind of the adversarial system. What are the roles of who are the different players and what are their roles? And then I also want to talk about evidence and super high level, very broad introduction to evidence. Let's see if we can make this work. There we go. Okay. So the first thing I think is important to know is that we have, Celeste did that great overview with the various courthouses that you could be in. And you could be in your local county courthouse, or you could be in your federal district courthouse. And so where could you be? And in many, many courthouses, your judge is going to hear civil cases and criminal cases, same judge. In fact, I went to law school in Nevada, practiced in Nevada, taught in Nevada for a while before I moved to California. And so in Nevada, we actually still have a circuit. There are some judges who still serve as circuit judges, meaning they actually kind of go in a circle. And so they'll do, Monday, Wednesday in one town, and then Tuesday, Thursday in another town. And that one judge will hear everything, family law cases, lawsuits between neighbors, criminal cases, wills cases, all the cases. In other jurisdictions, you might have one judge who specializes in criminal cases, one judge who specializes in civil cases. But you want to know that both of those cases can be, brought together through the same court system. They're going to, if one of the attorneys says, hey, I'm going to appeal, that can go up through the same appellate system that Celeste just outlined, and it's going to go directly straight up, right? I think it helps to start always with okay, why do these things exist? So I think the important thing to know about the civil lawsuit is that it's designed, somebody's been hurt, right? They've been injured, or somebody didn't fulfill a contract, or something happened and they need compensation, right? Versus the criminal law system is there to say, hey, something has happened in terms of, there's been harm, there's been a crime that's been committed, and we need to, get this dangerous criminal off the streets, or we need to teach this criminal how not to be a criminal, right? We can also look at who's bringing this lawsuit. Is it the plaintiff, like the individual person who got hurt or who made a contract that the other person didn't live up to? Or is it the government? Is it the people of the state of California, or the people of the state of New York, or who is bringing that lawsuit? That can matter later on when we get into talking about, say, evidence or other rules where it matters whether this is a civil trial or a criminal trial. When we talk about a civil trial and kind of two pieces to this, right? Generally, if somebody is found liable, they're going to get damages, which means money. They might get an order that says, hey, stop doing that. That's an injunction. Don't do that thing anymore. Versus in a criminal trial, they might be found guilty, and the penalty is going to be imprisonment, plus also sometimes a fine. So you want to look at that language. What's the language that for our purposes, the bar examiners are using? Are they talking about damages? Are they using words like liable? Or are they using words like guilty and punishment? Those kinds of words. It also matters because the standard of proof is higher for a criminal trial than a civil trial. So for a civil trial, more likely than not, sort of, does it seem more likely than not? Sometimes people will say sort of 51%. If you look at the scales of justice, more likely than not, just a little bit. Versus for criminal law, that beyond a reasonable doubt, that's kind of a big difference there, right? I've heard people say, that's kind of the standard by which you choose your spouse. Doesn't have to be 100%, but it better be more than 51, right? It also matters for things like when we get into the Constitution. So, for example, you have a right to an attorney in your criminal trial. You don't have a right to an attorney in your civil trial. So you always want to be thinking about kind of just, where are we? What kind of a dispute is this? Is this a civil dispute? Do we have neighbors? And one guy is upset about, how noisy and irritating his neighbor is, and he wants to sue him? Or is this, somebody who's committed a crime, and we're wondering if he can be found guilty of whatever that crime is. Once we've kind of figured out like where we are, is this like a civil situation or is this a criminal situation? You want to know that we've kind of got three main roles, three main sort of players, if you will, right? You've got the attorneys, and there's usually at least two, right? So you've got, if it's criminal, you've got the attorney for the state and the attorney for the defendant. If it's civil, you've got the attorney for the plaintiff and the attorney for the defendant. Sometimes it can get even more complicated because you have, the plaintiff and then the defendant's like, hey, it's not my fault, it's this other guy's fault. And then you get this another person and their attorney can be brought in. But at a minimum, you got, these two attorneys. And then you've got a judge, and then you've got a jury. And the jury is, more than one person, but they kind of all, they count as one entity for our purposes, one group that's all going to work together for our purposes. So what do they all do? Well, attorneys do lots of things. So, they serve as an advisor. And this is, kind of, what a lot of us think of when we think of attorneys, right? This is the person that you go to and you say, hey, I want to know how to make sure that my kids are provided for after I die. Like, can you help me set up my will that way? Can you tell me how I can write an employee manual to make sure that my employees are, using the company telephones the way that they should be? Can you advise me about whether I'm liable for these actions that I did? Am I responsible for the harm that occurred because of them? We just go to an attorney and we want some advice. Like, what should I do? You might also have an attorney that helps to negotiate, right? Just, can you help us kind of reach a deal? So one of the things that's going on where I live right now, the teachers are on strike, meaning they're saying, hey, we're not getting paid what we think is fair, and we're not going to go to work until we get a contract that we think is fair. And so the teachers' attorneys and the district's attorneys are sitting down and trying to negotiate a deal. So sometimes, they're not necessarily, in this instance, they want, both sides ostensibly want to reach a deal. They want to have that agreement. They just haven't been able to reach it yet. And so sometimes that's the situation. Sometimes that's what we're looking at. It's just like, can we get these people to an agreement? What does that look like? Sometimes they actually are in opposition. You've got that state's attorney and the defense attorney, and they're sitting there saying, like, can we, would you be willing to, take a 15 years for this crime? And the defense attorney says, no, I think he shouldn't have to do more than 5. And they're negotiating that deal. You've got a situation where the attorney might serve as an investigator. He has the power to interview witnesses or get documents out of the opposing party, get information out of that opposing party. You can hire an expert to review information or conduct experiments or what have you. And then the last thing, the one we're going to talk about kind of the most here on out, is the idea of being the litigator. And, you'll talk about this on the bar exam in lots of different ways. One of those ways is within the context of professional responsibility, right? Which is that you have this duty to your client to advocate for them, to serve as, we say, a zealous advocate. And, you also have a duty of, we say, candor or honesty to the tribunal. And to, you have to deal fairly with your opposing counsel, but you are expected to, be an adversary to that opposing counsel. You're expected to put up that fight, right? And create kind of be a thorn in their side, create an argument for them. So, the whole system kind of rests on that. A friend of mine is a defense attorney, and if you ask him, like, hey, what is your job? he would say, my job is to irritate state's attorneys. Like that's his perception of his job, is that his job is to just kind of stand in the way and say, look, you have to prove every element of the crime, and my job is to make you do it. So that's what I'm going to do. That's our conception of how that works, is that the police are going to go and gather the evidence. They're going to bring it to the district attorney. The district attorney can determine whether or not the charge should go forward. Once they've decided to do that, the defense attorney can then get that information and they can present their own arguments. And we're going to duke it out in court, and we're going to decide, we're going to present it to the jury, and the jury's going to decide whether or not the client's guilty. Or if there's been, some harm that's happened to somebody, and they go to an attorney and they say, hey, this person harmed me in some way. They breached our contract, or they got in a car accident with me and harmed me. Well, they're going to go to their attorney. Their attorney is going to be able to get all kinds of information from the opposing side. We're going to exchange information. We're going to go to court. We're going to present our arguments, and we're going to argue it out. We get to present all this different evidence, but we do have to operate within these strict rules. So we don't get to kind of just present anything we want to. We have to be kind of careful about how we present the evidence and what evidence we present. So when I talk about evidence, know that I mean testimony, like somebody getting up and sitting in the witness stand and saying something, and also documents, so reports or letters, whatever it might be, pictures. So, hey, here's a picture of the car accident, or here's a map of the crime scene, or whatever it might be, as well as, the prosecutor or defense attorney or what have you, delivering sort of an opening or closing statement. And while all that is going on, the opponent can object and say, objection, Your Honor, hearsay, or objection, Your Honor, that's irrelevant. And the judge is actually the one who makes that decision. So you've got these two attorneys, and they're arguing, and they're trying to present evidence, and they're presenting it to the judge. And the judge decides what evidence can be heard by the jury. So the jury doesn't get to hear everything. The jury gets to hear only that evidence that the judge has decided is, appropriate for the jury to hear. The evidence that the judge feels complies with the rules of evidence and whatever, other, rules there are that are implicated, like the Constitution, for example. The judge would also then instruct the jury on the law. So the judge might say, hey, if you decide that, the defendant was at fault here, then this result, if you decide, this thing, then this result, right? But the jury is the one that's going to decide the facts, right? They're kind of the ultimate decision makers. They're going to look at those documents. They're going to hold those documents in their hands. They're going to get to look at them. They're going to look at those witnesses, and they're going to say, like, does this person seem believable? Do they seem honest? They're going to listen to both arguments. They're going to decide ultimately who they believe. I was kind of thinking about, how do I describe this? How did I first learn about this? And back in the day, my mom used to, I mentioned I grew up in Vegas, right? Or grew up in Nevada. So I actually grew up in Las Vegas, which is sort of a 24-hour town. My mom would work in the evenings, and I grew up watching reruns of black and white TV shows. And one of my favorites was this old TV show called Perry Mason. Perry Mason was a defense attorney, and he would, of course, solve the case. And I was like, I wonder if I can find an episode of Perry Mason or a little clip of Perry Mason that would kind of show this. And I found one. And not only that, but I found one on YouTube that was this gentleman showing his mother as the actress in this clip, which I thought was super sweet. So hoping this will work the way it's supposed to.
Did your mistress carry a large sum of money with her during this last trip?
Oh,
But of course, she was going to Mexico.
that's not working.
And she always carried large sums of money.
Do you know how much?
$10,000.
How do you happen to know?
Oh, that's okay though, because I can fix it. Here, I'm going to rewind it about 10 seconds. Okay, so the gentleman who's currently asking the question is the state's attorney. He's the district attorney. This is a criminal trial, and he's questioning the witness in what we would call a direct examination. So he's kind of saying, hey, what happened? Tell us the story of what happened. And he's doing that by asking this witness questions.
Did your mistress carry a large sum of money with her during this last trip?
But of course, she was going to Mexico. And she always carried large sums of money.
Do you know how much?
$10,000.
How do you happen to know this?
I was with her at the bank just before we sailed.
Who was the first person to enter Agatha Alder's cabin after her disappearance?
Secretary, Miss Sally Fenner.
So you can see that moment when she kind of did that, you know, we would call that being shifty-eyed, right? Like she's kind of shifting her eyes a little bit. And you can decide, the jury would be the one to look at that witness and decide whether or not they believe her, whether or not they think she's credible. This woman here in this episode is the defendant. So she's got her own attorney,
went through her
Perry
personal
Mason.
belongings and effects. Was there any money there?
Nothing.
Thank you, Miss Santos. Your witness, Mr. Mason. You are a waitress, Miss Santos?
Yes.
What is the name of your restaurant, the one you work in as a waitress?
Las Chalupas.
Who is your employer?
Isidoro Martinez.
You live at 22 Edeline Avenue?
Yes.
And you are not married?
No.
Would it surprise you, Miss Santos, to learn that your employer, Mr. Isidoro Martinez, also lives at 22 Edeline Avenue? Your Honor, I resent this attempt to humiliate and degrade the witness.
So you can see there that Perry Mason is trying to bring in some evidence, and his opposing counsel, his adversary, is objecting. He says, oh, what are you doing? Why are you trying to introduce this evidence? And he's going to reach out to the judge and say, should the jury be allowed to hear this evidence?
Do not a court of morals, Mr. Mason. I'm not impeaching her morals, Your Honor, only her testimony. For the record, here is the marriage.
In a minute, I'm going to super briefly mention, you know, what does that mean? Like impeaching someone's morals? Like, what does that have to do with anything? But just hang on to this for a second.
Certificate of Nina Santos and Isidoro Martinez. May continue, Mr. Mason. Thank you, Your Honor.
So long story short, he just caught her in a lie. She said she wasn't married, but here's her marriage certificate, right? A document of evidence, her marriage certificate that he's been able to locate.
Now, Mrs. Martinez, who owns Las Chalupas Restaurant?
And the judge looked at it and said, yeah, the jury does get to hear this piece of evidence.
Perhaps this bill of sale will help your memory. Isn't it true that within 2 weeks after Agatha Alder died, you paid $10,000 cash as down payment for Las Chalupas Restaurant?
Yes.
And
Okay. And various other intrigues follow. But essentially, that was what I wanted to show, was that those sort of moments where you saw the pieces of documentary evidence be brought up, where you saw the judge consider them, where you saw the attorneys objecting and interacting with each other and with the witness. As Celeste notes, it is still TV. And also, by the way, there have been some changes to the rules since Perry Mason was there. But still, if you're thinking about how do you kind of wrap your mind around this concept of these two adversaries and they're arguing it out, and the jury, these folks, I think that's where he's situated, that they would be directly behind him, are looking at her and looking at her shifty eyedness and considering that she just lied to them about whether or not she was married and deciding whether or not they believe her. This is maybe a way to visualize that. Okay. So with that, I will, it does go a little bit on the rails after that. All right, now I'm going to go back and share the screen. Oh. Okay. So, let me make this big again because that makes it a little easier to see. Okay. So, all right. So now you kind of have your head, you can imagine Perry Mason and, there's no shame in it. I will tell you that throughout my law school career, I would imagine either Perry Mason, which was what I used to watch late at night when my mom was out working late, or Matlock, which is what I used to get to watch with my grandparents. When I was trying to imagine the rules of evidence, I would imagine those two lawyers arguing it out. So you can imagine that. But what does it look like on the bar exam? So you might get a question that looks something like, did the court properly admit? So they're asking you to evaluate the judge's decision. Some documentary evidence, like a hospital intake form. Some testamentary evidence, like what Pete said about what Aaron said at the accident scene, or Pete's testimony about Donna's statement at the hospital. And we're going to answer according to the federal rules, because like Celeste said, you could be in state court or you could be in federal court, but apparently we're in federal court. All right. So what about these rules of evidence? And I am going to stick with federal rules. You could have federal rules, you could have state rules, but today we're going to talk about federal rules. And I should say, even if you went to the state rules, they're very, very slightly different. For UBE states, they're going to adhere to the federal rules. For California, there are some slight differences that we would cover in much more depth, obviously, or I guess we would cover period in our course today. Again, huge, like big overview. What's going to happen? Each side gets to present an opening argument, and we're going to say something like, ladies and gentlemen of the jury, the evidence is going to show whatever we think it's going to show, right? We can then call our witnesses, and we can conduct what we call a direct examination, which is basically saying, tell us what happened. The opposing side then gets to get up and do that cross-examination. So as you saw, you kind of had that direct examination, but then you have the cross-examination when Perry Mason comes in and has that Perry Mason moment of, isn't it true that you're actually married? That kind of thing. Both sides get to present documents, pictures. These days, you get to present movies. You can do all kinds of things like that. And then at the end, you get to do a closing argument where you say, ladies and gentlemen of the jury, here's the things that we showed you. Let me remind you about the expert who said such and such thing. And don't forget about that wedding certificate that we found for you. And don't forget about, that bill of sale. Where did the money for that come from? Blah, blah, blah. So a couple of, again, general things to know about. Anytime you're looking at a piece of evidence, you're looking at that wedding certificate. First thing I want to know, is it relevant? And the test for relevance is pretty easy. The test for relevance is just, does it make any fact that matters more or less likely? Yes, right? Maybe, probably. But hey, just because it's relevant doesn't mean we're done. There's a whole bunch of other reasons why it could still be kept out. I'm going to super briefly just mention 3 of them, and you're going to remember that this is a super brief mention of 3 of them, and there's other reasons they could be kept out too. And we're going to cover that in more detail when you get to the bar. But you're going to remember the first hurdle is just, does it matter? Is it relevant? Does it prove anything about what the jury is supposed to be thinking about? So does it help prove something that the parties are having this disagreement about? The language that the rule uses is, does it have any tendency to prove or disprove any fact of consequence, right? All we've got to do. Once we've decided that it's relevant, we're not done, right? Because there's a whole bunch of reasons that we could still exclude it. One of the things to think about is just, hey, you know what? Policy, what we call policy reasons, basically meaning that the folks who wrote the rules said, look, yeah, this stuff is relevant, but because we want people to do this stuff, we're not going to allow it to come in at trial. So we're going to say, yeah, if you do these things, can't come in. So there you go. So for example, we want people to have car insurance. So if you have car insurance, not coming in at trial, except in very limited instances that we're not talking about here. If you find out that hey, some medicine that you made people sick, and you go, oh my gosh, I had no idea it could do that, and you fix it, that's not going to come in at trial because we want you to fix it. Even if you're not, even if you're like, yeah, it only makes you sick if you take it at 3 times the normal dose. What were these people thinking? We don't want you, we still want you fixing it. Fix the problem. Don't let people get sick. So even relevant evidence can still be excluded by the judge. The jury never gets to hear it because we don't want people saying, I probably should fix that, but might look bad for me if I ever got sued. So never mind. No, we're not doing that. Fix it. It's not going to come in. So that's one thing that can happen, right? The judge is like, yeah, it's relevant, but it's still not coming in for these policy reasons. All right. We also have this idea of so-called character evidence, which is basically just, hey, doesn't matter what you might have done in the past. The only thing the jury should be considering is, what did you do today? Did you do this bad thing? Doesn't mean it's always impossible to bring in character evidence. It's just you only get to bring it in under certain circumstances. So here's our judge, and he says, first, is this evidence relevant? And then he says it is, but it looks like character evidence. And then the attorney that's offering it says, wait, judge, wait. I think I have an exception to character evidence. Boom, it's back in. What are some of those exceptions? Again, there's a whole bunch more. I'm being super general here. Got to give my lawyer, caveats or whatever here. So for example, knowledge, right? So let's say that I have a history as a car thief. I don't actually, but just pretend that I did. And so I'm charged with stealing a car. And my defense is, I don't know how to steal cars. Never stolen a car in my life. Don't know how to steal cars. Don't know how to hotwire cars. Takes a level of, mechanical inclination that I just don't have. And then the state's attorney comes up with, hey, Jen, isn't this your conviction for previously hotwiring cars? Well, we're not admitting it to show once a car thief, always a car thief. We're admitting it to show, Jen, you know how to hotwire cars. Okay, fine. Or if it's relevant to this issue, right? So, hey, are you, is it a defamation issue, right? Are you the kind of person that, makes jokes about people's hair loss? Well, character might be an issue there. Or, as we just saw in that clip, does it call into question this person's credibility? We don't actually care whether or not she's married. Doesn't matter. What we care about is that she lied about whether or not she was married, because that makes it really hard to believe a lot of the things she told us, right? And we've got to think about how believable is that? How believable is that now that we know that she's lied about that one thing? Okay. And then hearsay. So, right. So maybe the judge was like, hey, is it relevant? And then he was like, okay, it's relevant. But what else? Oh, and then, somebody said, objection, Your Honor, hearsay. And he was like, oh yeah, let's get it out of there. And then the proffering attorney, meaning the person who was like, no, it's okay, we should be allowed to bring this in, said, wait, we have an exception here. So hearsay basically means exactly what it sounds like. You want to get up and testify about something that you heard someone else say. Oops, I'm sorry, you guys. What did I do? You want to get up and testify about something you heard someone else say. Okay? You can't do that. Right? Who knows what could happen? Maybe what did I hear somebody else say? Well, who knows? Maybe I didn't hear it correctly. Maybe my hearing's going. Maybe I'm forgetful and I've forgotten what I heard. Maybe I'm just a lying liar who lies and I'm lying about what I heard. And my poor defendant can't even cross-examine the person who actually said the thing because they're not here. And I'm just testifying about what I heard them say. So generally, you can't necessarily bring in that hearsay. Now, there's a whole bunch of exceptions, and again, we'll get in there when we get there, but just know that generally, hearsay, we don't like it. We don't want it coming in unless you can find one of those exceptions. So how might that look on the bar exam? Well, here's a multiple choice question. So something like this, right? And this is a question that has to do with relevance. So you've got a threatening phone call that purports to be from defendant to witness. And when would it be most likely to be admitted against defendant? And you've got A, the caller identified himself as defendant. B, the witness had previously given damaging testimony against defendant in another lawsuit. C, the witness had given his unlisted number only to defendant and a few other persons. Or D, the witness believes that defendant is capable of making such threats. Well, we know it's not D, right? You can believe a lot of things about a lot of people. Doesn't mean it's true. So we know it's not D. A, no, come on. Just because somebody says there's someone else over the phone, that doesn't mean anything. B would go to like motive or what we might call bias, but it still doesn't, really help to establish that the person on the other end of the line is actually the defendant. C is the closest one here. So this is how this question might come up. And you can see this is the role, as we're thinking about competency for attorneys, right? Like this is where an attorney is trying to gather that evidence that would help to prove their case. And they're having to think about what's the best way to help establish this. Okay, one last thing, and then I'm going to kick it back to Celeste. Last idea, and that is that, so we've got our judge, right? And he's like, okay, so first off, is this evidence relevant? Okay, it is relevant. Oh, but maybe it's hearsay. But wait, there's an exception that applies. Okay, so maybe it is in. But wait, if we've got a constitutional issue and we've got an evidence issue, the constitutional issue is always going to supersede the evidentiary issue. Okay, and they can overlap like that. So if you've got some situation where the rules of evidence and the Constitution are going to, butt heads, they're going to intersect, the Constitution is going to win. The Constitution is the bigger, stronger rule. So even if the judge has thought to herself, okay, so it is relevant. There are none of those weird, like other reasons to exclude it. Whew, okay, good. But there's some constitutional reason to keep it out. It was a bad search. It was impermissible under the Fourth Amendment. It's got to go out. One of the more common ones that you'll see in evidence is going to be the confrontation clause. The confrontation clause, again, it's one of those things that means exactly what it says, which is the defendant gets to confront the witnesses against him. So if we think back to hearsay, I heard someone say something. So if I'm testifying about what I heard someone else say, you can't confront the person who said the thing because they're not there. We got a confrontation clause problem. So the judge says, okay, is it relevant? Yes. Oh, but it might be hearsay. Oh, but maybe there's an exception. Oh, but the confrontation clause is still at issue because the actual person who said the thing is not here for the defendant to ask all those questions like, are you somebody who just is lying? Are you someone who doesn't like me? Are you making this up? They're not there. What does this look like on the bar exam? This is from an old California question. So you have two guys, two criminals, Art and Bill, and they kidnap the victim, Vicky, who is distressed because she's been kept for several days after being kidnapped, and she commits suicide. Bill had explicitly told Art, make sure nothing bad happens to Vicky. Art doesn't do a good job of that. Art confesses to Bill, this is what happened. So Bill hears Art say something bad happened to Vicky. Bill is like, oh my gosh, how could you do this? He runs off to the police station. Now we've got this question. Can the police testify about what happened? About what Bill told them, Art told him. And you've got an evidentiary question around hearsay, but you've also got a constitutional question around the confrontation clause. And so as examinees, you've got to put on that judge hat, and you've got to, or I guess judge's robe, because they were robes, not hats, but whatever. And think about, not just the evidentiary piece of like, okay, so it might be hearsay, but here's the reasons that it might be admissible under the hearsay rule, but also what about the Constitution? And so with that, I know I just like sort of threw a whole bunch of stuff at you, but again, it's an overview. We're going to get into more depth when we get into the course. And we will also have time at the end for questions. But with that, I'm going to kick it over to Celeste, who's going to talk more about the constitutional piece about it. Blah.
Okay, when you stop sharing, I'll go ahead and share my screen. We're just going to make this so smooth. Here we go. This is the one. All right, well, we don't want this and we don't want this. Okay, so what we have covered so far. Thank you, Jen. First of all, I want to thank you especially for the Perry Mason as much as I teased you for it. You kept it to the good part of the clip, which was, before the attorney went off and started just like making a bunch of argument. One of the rules of evidence is that evidence has to proceed by question and answer. And if you just keep watching that clip, one of the attorneys just starts making an argument to the judge. So I'm glad Jen didn't show that part because we would have confused people. But the part that she showed was great. It was, how the people present documentary evidence. But it's also important what she just said, that even if the federal rules of evidence would allow a piece of evidence to come in, the confrontation clause might kick it out. Now, why? Are we pulling our hair? No, we're not. It's what this is a supremacy issue. Supremacy is a clause. It's part of the Constitution that says the U.S. Constitution is the supreme law of the land. So the Constitution, federal statutes, where they conflict with what would otherwise be going on at a state level, the federal will win, okay? Will prevail, will control the outcome. Same, yeah, so especially we see that come up with constitutional issues. So this is a federalism issue. This is an issue of which law controls. I got some questions about appeals, so I want to circle back to that in the Q&A because I don't have too much here and we want to talk about it. This is something that even bar students struggle with sometimes. When you are dealing with a question of state law, the ultimate final arbiter, the final authority on what a state's particular laws mean is that state's highest court, okay? The state Supreme Court in most cases. So oh, sorry, this one, that's not my examples. I must have changed it. It was, whether a certain action constitutes negligence. That was my example. Sorry, my slide had an error. So these are things like torts, contract law, state statutes, okay? Things like tort law, state common law, contract law, state common law, state statutes. Those are controlled by state law. And that means if we're working our way through the state court system and we get to the state Supreme Court and lose on our contracts case, we cannot then appeal to the US Supreme Court. Why? Because the US Supreme Court does not get to overturn a state on a state law issue. Okay? And on a federal law issue, the final authority is the US Supreme Court. So if there's a federal law issue, sometimes there is an appeal taken from a state Supreme Court to the US Supreme Court. And where we see this come up, right? So the highest court of each state is the highest authority as to state law. The United States Supreme Court cannot disagree on a purely state law issue. I just said that, but there, I wrote it nicely there. Whether defendant's actions breached a duty of care under state A negligence law is for state A to decide, okay? The United States Supreme Court is the highest authority as to federal law. So that's federal constitutional issues, that's the Federal Fair Housing Act, and every other federal statute, pollution or any other federal statute you can think of, the United States Supreme Court will be the highest authority. Same with stuff about treaties entered into by the United States. Okay. What if a state statute violates federal law? Or at least that's somebody's argument. Okay. If a state statute violates federal law, US treaty, United States Constitution, the challenge to that law is a federal claim, even though we're talking about a state law. So one of the big freedoms protected by the Constitution, it's in the First Amendment, we have the freedom of speech. Government cannot come in and tell us what to say and how to say it. With some limits, like not threatening people. Again, you'll learn the details in the, it's in the last section of the constitutional law lecture in BarMax. But let's say we have free speech rights guaranteed by the Constitution, and state B passes a law that bans lawyer advertising. Whoa. And so the lawyer says, hey, I want to advertise, and I have a right to do this under the US Constitution. So it's a state law that's at issue here. It's a state B law that says no advertising. But the lawyer says, my constitutional rights under the federal Constitution make your law unconstitutional. Your state law is illegal. This law is illegal. So that argument is a federal claim, whether brought in state court or federal court. Both courts are competent to hear that claim, okay? But federal law will control the analysis, whichever court it's in. And the rule, and you would learn it in BarMax, is any restriction on truthful commercial speech must serve a substantial government purpose, must directly advance that government interest, and must be narrowly tailored to that interest. Okay, this is an intermediate scrutiny standard. You will get there. Don't worry. By the time you take the bar exam, these kinds of things will be rattling off your tongue because these are constitutional standards that you do need to know. So where would we go if the state Supreme Court disagreed and said, no, this lawyer advertising ban is just fine here in my state? No, the lawyer then appeals to the United States Supreme Court and says, excuse me, state B, what did I say? State B is doing something unconstitutional over here. And the US Supreme Court can hear that case. Hopefully that something that obvious wouldn't happen because those cases have already been argued and decided before the Supreme Court. There's a certain amount of lawyer advertising that is now allowed, as you know, if you've ever driven on a highway. So that's one issue I wanted you to know about in which law controls, because like going into this, recognizing that there are state courts and federal courts, there is some interplay. There are times when the appeal from a state court will jump into federal court because it addresses a federal issue. Now, someone asked in Q&A, can something ever jump a level to go straight to the federal Supreme Court? In other words, can the federal Supreme Court take an appeal from the district court? So going back to my earlier diagram, can we jump from here to here? And the answer is generally no. There is one narrow class of cases where it is allowed to make that direct jump. You don't go through the courts of appeal. And this has to do with jurisdiction. Okay, so I saw that, I'm sorry, not jurisdiction. It has to, scratch that. Injunctions. I got distracted. Sorry. Okay, so when a 3-judge panel of the district court decides that it is necessary, so it's actually 2 district judges and a circuit judge, and they decide that for this particular issue, either to grant or deny an injunction, or then obviously injunctive relief, preventing somebody from doing something, is a fairly weighty form of relief, often more so than money, because somebody has to not do something. So those narrow band of cases jump straight to the Supreme Court. But other than that, most cases have to go through all 3 steps of the federal process. They have to go through a circuit court, that is a United States Court of Appeal for a particular circuit. And I'm getting some, okay, Jaime or Jamie, sorry, I don't know how to pronounce your name, but I see that you've asked, can you ask questions about anything at any time? Well, within BarMax, you can hit the support button and we'll give it a try. We have instructors that look at that pretty much, weekdays, and we'll try to answer content questions. Here in the webinar, we're going to try to take stuff that is relevant to the question. Jen, can you hop in on California? You still around? Can you hop in on California? If Jen had to run get a snack, I don't blame her. Oh, there you are. If you could kill your mic, turn on your mic. So there was a question from someone named Simba, and I answered it and realized I didn't send the answer to Simba. I sent it to Katie. But it was a good question. I thought I'd go to you about appeals in the California court. Do cases have to go through multiple levels of appeal? And the answer is kind of, it depends which court originally had jurisdiction over it. Can I let you take that from here?
Yeah. So, so I think that the answer would be, in general, yes, they do need to go through. So, and I think also at the end there, when Celeste was kind of walking through, when do you get to go? So you want to kind of think about, okay, so you're going to go to the superior court, right? Which is where you have your lawsuit. And then maybe you win or lose and you appeal. I guess you'd only appeal if you lost, but whatever happens there, you appeal. Maybe you win on part and you lose on part, whatever. So you appeal, and then you would go to the state Supreme Court, right? Based on whatever happened at the appellate level. But here's the deal, right? Like, once that state Supreme Court has made their decision, if it's a matter that is solely about California law, we're done. Right? Like that's the end. There isn't, even though we talked about how like the US law is supreme, unless there's a matter of US law at hand, there isn't really anything there's no other place for our person to appeal to. I'm trying to think if there's any situation where the California Supreme Court would have original jurisdiction, and I'm not thinking of any offhand. So I think that's it.
Okay, so Jen, I am gonna pull up where that is in the outline since I'm here anyway, and I did jump over to, I'm in con law right now, but let me go back. I'm in the California outline right now. So those of you who are in New York or Nebraska or any other state, don't worry about the parts that are in blue, okay? Because when I look at the civil procedure outline, all the general stuff is here in the first 7 sections, and everybody has that. But then California gets this little special version of the outline where some stuff is in blue, and that's the California distinctions. So don't worry, you will not have this confusing stuff if you are not in California. But just to show down here in appeals, well, first of all, the jurisdiction issue. No, everything says jurisdiction here. I'm just going to have to scroll to the blue. So if you'll notice the subject matter jurisdiction, things go to the superior court if they're not in, probate court or municipal court or some other court, specialized court. If they're not in a specialized court in California, they go to the superior court and then they get appealed through that 3-level process. And then when we're looking at appeals, I felt like there was something helpful here. I didn't see anything about original jurisdiction in here for, California Supreme Court. But again, good questions. But if it's not in here, it's not on the bar, right?
Yes.
So,
and I would say honestly, like I've never seen a question about like district court, where that was the like where you had to know, like, district court, whatever, either on the bar. So, but I mean, I think it's good to know that there are those, hey, this is the cutoff for small claims court versus, superior court. And it's good to know for the federal court too, right? Because I think you will see those kinds of things on the MBE where you'll see something like, does this matter that relates to, immigration law? Can that, where does that get heard? Well, it gets heard in the immigration court, right? It doesn't get heard in sort of your general federal court. And I think Mulukal asked a question, what about an appeal from a state court? Does that appeal go through the 3 federal court structures? And the answer to that's no, right? So as long as it has to do with the state court law, it's going to go up through the state court state appeal, appellate court, state Supreme Court.
I'm turning now to the question.
And then you're kind of done unless there's some, question of U.S. law that's in there as well that you could take to the United States Supreme Court. But
and then you can jump straight to the Supreme Court. It's covered here in this section in BarMax on Supreme Court jurisdiction. I'm showing you some of our outline. So the Supreme Court hears appeals on questions of federal law. They can hear from the highest state court. So they can hear directly from the highest state court if it is a question of federal law. They do hear from the circuits, the Federal Circuit Court of Appeal, and the other question earlier, just the one circumstance where it would jump from district court. So yeah, that's that. And then what do we have still in? Is there anything else left? Oh, so the reason, Chica, I've been ignoring you. And the reason why is you ask something that gets into really the heart of the civil procedure course, because now we're talking about the Erie doctrine, which is, now we're deep in civil procedure, but we can hit this because come on, we don't want to leave you hanging. Chica asks, can you explain how to tell when to apply state substantive law and federal procedural law in diversity of jurisdiction cases? I guess we could say always. Okay. If you're in a diversity case, then you apply, meaning, which if you don't know what a diversity case is yet, don't worry, you will. It's one of the ways that cases get into federal court. It means you've got a state law issue and people from different states involved. So to that case, you apply, so let's say it's tort, you apply the tort law of that state. But for procedure, you're always going to apply the federal rules of civil procedure. Okay. So that's the Erie doctrine. And you've stated it correctly, but as a question. So the answer is yes, do it.
I mean, like how do you do it? You do it by asking that question and then doing it. And I guess, where folks can get tripped up sometimes is kind of like, well, how do I know if it's substantive or procedural? And that in real life, this can get a little bit complicated, but for the bar exam, I would say, look at whether or not this rule is outcome determinative. And that can be a pretty good indicator. Like that's something that we look at in real life, but then like the court can sometimes kind of, I don't know, add other layers to it. But for the bar, is it outcome determinative? That can be pretty good.
Like forum selection clauses in contracts that has tripped people up. There's sometimes a phrase in a contract that says, this contract will be heard in the courts in Florida or something. And forum is a procedural issue. So the federal courts don't have to obey the forum selection clause. It's a procedural issue. Whereas choice of law is a substantive issue. So some of them are tricky, so you go through them. Those were tested in some MEE essays. So you may not have seen it like difficult on the California bar. I know you teach the MEE as well, but it has come up. It has come up. So there are some tricky issues on the border, but most issues are not on the border. You're dealing with a state statute or a torts claim or a straight up contracts, breach of contract or defamation, something like that. That's definitely state law. And then you'll know that the procedural aspect, anything about, when things are due and all of that, that's going to be governed by federal law. One tricky issue is privilege. Privilege is another tricky one. Okay, so privilege is governed by state law. If the state protects that privilege, it will be protected in a diversity case. That's a weird one. So yeah, some of them you just need to know. That's covered in the evidence lecture. Jamie, I don't know what FDLE is.
Yeah, Jamie, you need a Florida lawyer.
Oh yeah, sorry. Yeah, this is beyond us. This is beyond us. Definitely not on the bar exam. So we're not gonna be able to take that one. Yeah, I saw something about, anyway, we won't. If somebody's having a real legal issue and they need a real lawyer. A real Florida lawyer. All right. Well, hey, I want to thank you who've been hanging in there with us. If you got here a little late and need a little bit of a refresher on who we are at BarMax, we offer a comprehensive course. You get people reviewing your essays and giving you feedback. So start turning them in early. If you're in BarMax, it's not too early to turn in essays to make sure that you're using the format you need to use to get all the points on your exam. You get all of the outlines. I showed you some snips. You get all of the past exam questions. You get all of the past exam essay and any released multiple choice question that we have, all the released ones. They don't release a lot of multiple choice, but we have it's more than 1,500 that are out there. And we also offer tutoring, so you can buy them in a bundle or separately. And we handled Q&A. We did it. Okay, we've done that for today. We've done our Q&A, and the recording will not be sent, but I think a link to the recording gets sent. The recording will appear in two places. One will be the TestMax YouTube page. There are all kinds of really helpful videos on there. My favorite study strategies, Jen talking about certain aspects of the exam, and some, there's all kinds of helpful stuff on there, but it will also be posted within BarMax under the office hours page, which is a clock. It's a little icon of a clock. So if you see the, if you look at the videos there and you're within BarMax, you've purchased a BarMax program, there are a ton more videos, like more than are on the YouTube page, like more than twice as many more, where we talk about some specific content subjects. I did an overview of secure transactions that right before the exam that apparently came in handy because secure transactions did appear on the last UBE. We've done things about, defenses to negligence and things about, search and seizure and, specific areas we'll go into. And Jen also offers all kinds of study advice. She's got more ed psych background than I do. And I would say that her session on taming your inner critic and some of her other sessions about dealing with the mind game of the bar, worth the price of admission. I'm telling you, great stuff available within BarMax. We may have one more webinar. Keep an eye on your email. I have not scheduled it yet, and we'll be talking to an instructor offline. And we will have tons of office hours in the upcoming season. So one more webinar that's open to everyone, whether you're in BarMax or not. We like to provide some helpful information, and then a bunch of office hours after that. Yes, the new release questions. Oh, you were going to answer that. I'm sorry.
I just said yes, but please elaborate.
Oh, yes. Somebody asked about the release questions that came out in December. They're in BarMax. They're on the website version. If you don't see them in your app, check the website. They're there underneath the 4 OPE online practice exams, the 200 brand new, spanky shiny released questions. Thank you so much, you guys, for being engaged, for sticking around. And I wish you all the best on your continued studies. And if you're taking the bar exam this July, we are here for you. So good luck on that, and reach out to us. We'll help in whatever way we can. Thanks. Bye-bye.